kind of thing usually happens to me, and it probably will before the day's over. We're not counting your time yet, don't worry.
Good news, I don't have any more water to spill, so.
It's the tall glasses.
All right, let's go. Thanks. Okay. All right. Sorry about that.
No problem.
No problem, thank you.
All right, good morning. May it please the court, I'm Andrew Mills of the Dickson County Bar. I represent the petitioner and appellant here today, Aaron Ostine. I would request to reserve 5 minutes for rebuttal.
5 minutes, certainly.
Thank you. Your Honors, the issue presented today is whether or not the post-conviction court erred in denying the appellant's claim for ineffective assistance of counsel under Strickland v. Washington when the appellate's trial counsel failed to object to the state's reference to the victim's and the appellant's race during closing argument and investigate 2 alibi witnesses to corroborate that appellant was not present during the victim's death. The facts in this case are relatively straightforward, and they point to deficient performance by trial counsel and prejudice to the defendant under the lens of the cumulative errors doctrine as outlined in our brief. Now, as raised by the state in its brief, this court has examined one of the key facts we've presented in our brief, specifically 5 facts. But this court already considered the prosecutor's reference to the appellant's race. But this court has not considered the prosecutor's reference to the victim's race or to trial counsel's 3 references to the defendant's race. So specifically, this court considered the following statement from the prosecutor. Quote, "And the victim was in his home, and he just wanted to live, folks. He wanted to live, he just kept struggling to live. Sounds like he couldn't trust the black guy from Nashville to let him live." This court already considered that statement, found it to be prosecutorial misconduct, and concluded that it violated the standard prohibiting argument offered to intentionally inflame the jury. And this court agreed that the statement about the defendant's race was both unnecessary and irrelevant. However, this one-off statement, because that's what was raised about the black guy from Nashville, did not affect the jury's verdict because of the strength of the evidence in the case. Now, looking to what a reasonable attorney would have done.
Now, let me ask you this.
Yes, sir.
The trial attorney, in his testimony, said that he knew that the prosecutor crossed the line.
Yes.
And made a tactical decision not to object because he felt that he could still raise, even though he didn't object, that he could still raise it on appeal and it would be considered. He raised it in the motion for new trial, and the court considered it, the substance of it, and did not find reversible error on that or error on that. And then it was raised again in the trial in the appellate court, and they looked at it and gave it a full review and found that it wasn't prejudicial.
Yes, Your Honor.
Okay, and you're saying that the attorney was ineffective for not objecting?
I am, Your Honor. And that's due in part to the inconsistency in his actions and his testimony. As Your Honor just pointed out, Mr. Flanagan testified at the post-conviction hearing that he didn't object because, number one, it was trial tactics. He knew he was going to be able to bring it up before this court, and he did. 2, he said he didn't want to draw further attention to the defendant's race, right? In his motion for new trial, he certified to the court, and this is right after trial versus 10, 11 years later trying to remember. He said specifically in his motion for new trial that it was not a tactic, that it was not strategy, and he was seeking relief from the court in that motion for new trial. And we submit that that is more accurately what he was doing because of the other 4 statements that we are complaining about to this court today. The second statement was also by the prosecutor in the record on page 141 in their closing when the prosecutor said, quote, "They couldn't leave this white man this way, and that's why you've got these bloody footprints right over here." Trial counsel did not object to that statement either. When questioned at the post-conviction hearing, he didn't know why he didn't object or should have. It didn't cross his mind, I think, were his words. So I think that's more reflective of, again, what he stated in his motion for new trial, and that it wasn't tactic. I didn't object. to the first one when he talked about my client's race. I didn't object to the second one when he talked about the victim's race. And then I think it's very important for this court to consider the 3 statements made by trial counsel in his closing pointing to the defendant's race. And if I may, those 3 statements, first on page 149, does it matter in this case whether or not he is a green man from Mars? No, a black man from Nashville. He's trying to get you to hate him. Number 2, and again, this is all by trial counsel. You can't be led astray. You can't be fired up in a speech so you will hate the black guy from Nashville. And finally, these last 2 are on page 168 in closing for defense counsel. The prosecutor is wanting you to send a message across the river. You black guys from Nashville don't come here. So if he meant what he said in the post-conviction relief hearing, that he was doing it tactfully and didn't want to draw attention to his client's race, talking about it emphatically, not benignly, emphatically, and I would argue prejudicially, 3 times in his closing, right after the prosecutor referenced the victim and the defendant's race. Those are 5 of the key facts that we are pointing out for the court today, that under the circumstances, we can't look hindsight, we can't have the benefit of 2020 in a Strickland analysis, but in that moment, that was ineffective assistance of counsel. Because when you look at what he did at the time, it was not tactical. It was not trial strategy, and he certified that to the court.
It seems to me,
Yes,
whether
sir.
it's good strategy or bad strategy, whatever else, trial counsel was trying to convince the jury that the prosecution was trying to convict the defendant, not based on the evidence in the case, but based on the color of his skin. That seemed like, again, whether it's a wise strategy or a poor strategy, not the issue. It seems like a strategy.
It certainly was a strategy, but just because it's a strategy does not insulate it from being considered ineffective by this court. I think this court also has to consider, and it's clearly in the record, this is a black defendant with a white victim and an all-white jury. I think that's a dangerous gamble to then, especially when he testified in the post-conviction hearing that he didn't want to draw attention to race, to then overtly emphasize it in closing. I mean, they're irreconcilable. And that is part of what we are complaining of today.
Counsel, is it in the record that it's an all-white jury?
Yes,
Okay.
it is. And I'll find the site for you in a moment.
Oh, it's okay.
The biggest issue with it all is, and you 3 were trial judges, these juries, for the most part, are not learned attorneys. But they have 2 learned attorneys arguing at closing, talking about race, and a litany of other things. And there was no chance for a curative instruction from the court. No chance where juries get their law. The pattern jury instructions, the court tells the jury, here's what you're considering. And there was no opportunity for a curative instruction in this case because trial counsel didn't object the first time prosecution mentioned race, the second time prosecution mentioned race, and then brought it up himself. I guess he's not going to object against himself. But there was no chance for the court to say, don't consider this. In this country, we judge people based upon their actions, not who they are, as the U.S. Supreme Court has found in Pena-Rodriguez in 2017. There was no chance for a cure, and that taints this result. That when the trial judge cannot tell the jury, don't consider that, because otherwise, they're hearing 2 learned attorneys. Mr. Flanagan testified in this case. He's had over 400 jury trials. He knows what he's doing. But that doesn't mean, that quantity does not mean he doesn't make a mistake. And I think he made a mistake in this case. When these 2 attorneys are talking about race, without being told otherwise, a jury would almost necessarily take it into consideration, take it into deliberation, because no one told them otherwise. So the other compounding factors that I would ask this court to look at, again, under the cumulative errors doctrine that we are basing a majority of this appeal on, is the fact that it was an all-white jury, and the second issue we raised, trial counsel's failure to investigate alibi witnesses.
Let me ask you this question. Who are the 2 alibi witnesses you're talking about?
The 2 alibi witnesses are, I believe, Old Man Sammy. They did not testify at the PCR hearing.
I understand that, and isn't that a problem?
It is. The typical rule in black says you must have alibi witness testify at your PCR hearing, but I would argue that there are exceptions to that. When trial counsel's efforts to investigate were so deficient.
Okay, let me ask you this, because many, many years ago, I was a public defender, and I've had people say, hey, if you go talk to a dude on the corner, he'll tell you I didn't do it.
Mm-hmm.
And you can never figure out who he's talking about. There's no, there's just, I know who he is, you just got to find him.
Right.
I didn't see anything in the record where these people, other than one of them, I think had a barber shop and I think was dead.
One was dead and one worked at a barber shop by the time we got to the PCR hearing 11 years prior.
Okay.
And could not be found.
But I'm saying is the identification of these individuals was pretty thin as far as trying to actually locate them. And then of course by the time the PC hearing comes up, we have no body in the courtroom testifying what they would have said, which under Black and a lot of other case law says is pretty destructive to an argument that these witnesses should have been called.
2 points to that, Your Honor. First, it is pretty destructive. But when justice so demands otherwise, the rule in Black can be set aside to afford the defendant not to be put in a double bind. If there wasn't... Then the testimony is whatever the defendant says the witnesses would have said. That's what we're supposed to take as the proof? No, Your Honor. I think, again, we're looking at the cumulative errors doctrine. This is but one of the many errors we are complaining of.
We don't know what they would have said.
No, we don't.
So we can't speculate. That's what Black says. You can't speculate to what these witnesses would have said. You have to hear their testimony. So without hearing these witnesses, how can we say it was that this was error on the part of the defense attorney not to call him?
I think it was error before that, Your Honor, that he didn't actually go investigate. His testimony at the post-conviction relief hearing was that he talked to one lady who was uncooperative. That was his extent of finding witnesses. Okay. And more importantly, Your Honor, when this court, and we cited this in our brief in the Metz v. State case in 2021, the court looked at everything when looking under, was it ineffective, was it prejudicial, and looking to the cumulative errors. They looked at, did you reject any letters from any friends or family? Which, again, any one of these is not going to be prejudicial. Because there were no witnesses able to be produced at the post-conviction hearing, that's not going to be prejudicial. It could be ineffective, but it's not going to be prejudicial. These statements we talked about earlier, no one of them is going to be prejudicial. It's the cumulative effect of trial counsel that can render it prejudicial.
Cumulative effect of what, though?
Of the deficient performance.
But we don't know we don't even know if these persons existed. It's a situation where, how can you say it was part of this, well, it's cumulative because you have these witnesses that didn't testify. We don't know, A, if they existed, or B, what they would have said. So how can we then stretch it to say that the attorney was ineffective for not calling these people?
I don't think you'll be stretching it, Your Honor. It is but one of the many examples. Again, by itself, it's not going to win. It's not sufficient for the defendant to put that forward. In fact, say we lose on that. This court can even say we lose on that issue. The other 5 facts raised we submit are enough to say that was cumulative error during the closing argument process by both the prosecution and the defendant. But if I may, Your Honor, in the Metz case, this court looked to various factors, errors by trial counsel, including failure to speak to and interview witnesses, ignoring letters from friends and family, and statements made in open court contrary to the defendant's own interest. And this court found 2 of those to be ineffective, and because of the cumulative error, found it to be prejudicial, where one alone would not have, in isolation, would have been harmless, just like this court already found with the one statement that came before the court in 2015. It was harmless. Now you have 5 statements. Now you maybe, arguably, candidly, thinly, have an alibi witness investigation argument. All of that together points to the cumulative errors doctrine. And from a public policy standpoint, Your Honors, this case is, the state has said in its brief, and we've admitted the evidence this court has found was strong against Mr. Ostine at the trial. But that's not what this appeal is about. This appeal is about race became such an overwhelming factor at the end in closing argument that the result is tainted. If the state's evidence is so overwhelming, they should have no problem proving at a trial that does not involve race, that does not taint this result, that undermines confidence in the system. We are not asking for a reversal. We are asking for a new trial. Thank you.
Thank you.
Good morning. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, this court should affirm the judgment of the post-conviction court. With respect to his first issue, trial counsel made a strategic decision not to object to the prosecutor's statement about race. He said, I knew that this was an issue that the Court of Criminal Appeals was interested in. I knew they would do plenary review, and this court did exactly that. And this court found on direct appeal that there was overwhelming evidence against the petitioner and that the prosecutor's statement did not taint the record or the trial at all. In fact, the trial counsel was so prescient that what we're actually referring to on direct appeal is Ostine 2. Ostine 1, this court affirmed the judgment, but then the Tennessee Supreme Court in State v. Nora Jackson, a prosecutorial misconduct case, came out, and the Supreme Court remanded to this court and said, reconsider in light of Jackson. So trial counsel knew that this was an issue that this court would not waive and that this court and the higher court was interested in. And so it was a strategy, and with respect to the other three statements that the trial counsel said during closing argument, I looked at the record yesterday. That was not raised in the petition for post-conviction relief. Mr. Flanagan was asked no questions about that at the post-conviction hearing, and the post-conviction court made no findings on those three statements. So what we have raised and properly before this court are the prosecutor's statements, one on the defendant's race and one on the victim's race. And if you'll just allow me really briefly to give you the summary of the facts in this case that this court found overwhelming. The petitioner confessed in this case on video, and he said, I done it, I done killed that man, I am the trigger man. And he also said, I beat the hell out of him. And the medical examiner's testimony said that the victim had 5 deep lacerations that could have been caused by being pistol whipped. The gun that a co-defendant borrowed was the gun used as the murder weapon. The petitioner, when he gets in the car after killing the victim, he said, he told a co-defendant, the victim kept moving around, so I kept telling him to stop, and he didn't, so I beat him, and then I shot him in the back of the head. And the medical examiner's testimony is that he was shot in the back of the head. I could go on. There's DNA evidence of shoes found in a dumpster, DNA evidence found on gloves that could not rule out the petitioner. But again, this court found it was overwhelming evidence, and we agree, and that there was not deficient performance, and that he has failed to show prejudice with regard to that issue. On the second issue, Black v. State, Your Honor, it's 100% Black v. State. Counsel has done a really great job of finding a case from 1998, an unreported case from this court in State v. Williams. That case is completely distinguishable. It has a very unique set of facts, which I'm more than happy to give to this court. But since 1998, this court has cited that case 7 times, and in those 7 times, it has found it distinguishable and has always referred to and relied on Black v. State. And as Your Honor noted, we have no idea what these people would say. And the petitioner at trial testified on cross-examination. He said, I was playing dominoes with old man Sammy. So the jury heard that, but they obviously did not accredit that, and again, in light of the overwhelming evidence. If there are no questions, we ask that you affirm the judgment of the post-conviction court. Thank you.
All right, thank you, General.
Your Honors, good morning again. Just a few quick points from State's argument in the brief. Again, I pulled out the motion for new trial that defense counsel filed with the courts, filed December 7th, 2012, on page 108 of the record. Paragraph 5 states, the defendant should be granted a new trial as a result of prosecutorial misconduct. The prosecutor referred to the defendant as that black guy from Nashville. The comment is clearly plain error requiring granting of new trial. Defense counsel's decision not to register a contemporaneous objection to the improper comment was not the result of trial tactics or strategy. And he said that to the court right after. At the post-conviction hearing, when Mr. Flanagan was testifying to what his thinking on his strategy was at the time, he opened the door to his own comments. When he said, I didn't want to draw further attention to the defendant's race, it opened the door for review by this court, and this court has...
Let me stop you for a second.
Yes.
What the state mentioned, and I went back to look, and I remember thinking about this, is that these remarks made by defense counsel, that was never really raised at the post-conviction hearing, and the court never ruled on whether or not the lawyer was ineffective for going into race himself.
Yes, Your Honor.
Okay, so how is that now an issue before the court for us to take into consideration?
Your Honor, I would argue and submit to the court that under the cumulative errors doctrine, this court has the ability...
Aren't we looking at having to see whether the trial court erred? And if it's an issue that was not raised before the trial court, that the trial court never addressed, then how are we then supposed to then find error when it was never raised?
Those statements were in the record. They were admitted.
I understand, but they were not... It was not the subject of the post-conviction hearing. It was not brought to the lawyer's attention. And the court didn't then make any findings about whether it was ineffective. Your argument is that this shows he was ineffective because he did these things.
Yes, Your Honor.
The court never found that.
Well, the focus was on the prosecutor's statement.
I understand, and that was, went back to look at your brief, and that was the big focus of the brief, was that the defense counsel did not raise this as an objection at the time.
Yes, to either one. And I think it just shows more of that. This court wouldn't have to hang its hat on the three statements by defense counsel, but I do believe that it is relevant in light of his testimony at the PCR hearing and in light of the thrust of the brief being the two prosecutorial statements, only one of which had been reviewed by this court previously. Your Honor, unless there are more questions, that is our case, and we appreciate your time and consideration today.
All right, thank you, Counselor.
Thank you.
Well-written briefs for both parties, and we appreciate that, and good arguments. We're going to take a 10-minute recess, short, but 10 minutes.
All rise. This court is now in recess.